after the elaborations and speeches about most privacy-focused stuff, I will talk about some other specific issues related to the legal aspects of artificial intelligence. So I will touch the intellectual property rights issues, the liability, and I will give you also some regulatory hints, in particular from the FDA, which is the only body that has issued something concrete about the use of artificial intelligence. So first of all, some some flavors about the current scenarios. Mr. Mazzini already talked about the increasing role of artificial intelligence in today's medical practice, and I just put here some information that I found on the press recently about how actually artificial intelligence is now working and is actually smarter and faster than humans. So I think that to some extent we are at the beginning of what I would call the golden age of artificial intelligence nowadays, which is very similar to what we experienced in the early 90s about the internet, the golden age of the internet, and the early 2000s in the golden age of genomics and genetics. Why it's a golden age? It's a golden age because there is a complete lack of regulations, and therefore companies are basically doing whatever they want, and they are able to exploit their powerful tools to their benefit, and to some extent, hopefully, to the benefit also of the public. At a certain point, hopefully, some regulation will come, and this golden age will not end, but will be, driven and set on a more stable route. The artificial intelligence can be, placed within the big area of the digital medicine, which encompasses a variety of technologies, from, of course, artificial intelligence, then the blockchain, the use of health and wearable apps, the enhanced and virtual reality, and the increasing use of communication, not least the 5G, which will actually revolutionize the concept that we today have in the sharing of data. How artificial intelligence should be. This is more ethical, so I will only touch very briefly this aspect. Artificial intelligence must be accountable, transparent, and explainable. Transparency means that the organizations that use artificial intelligence must provide information about the fact that they are using artificial intelligence technology, what is the intended purpose of their use of the artificial intelligence, how the artificial intelligence will act and interact with the user, and the type of data sets that they will use and they will feed into the artificial intelligence system. The explainability means that the organizations must, again, provide accurate information in a humanly understandable way. As it was previously told, of course, we cannot, as laymen, understand how the artificial intelligence works, but we at least can understand what the artificial intelligence can do for us, and at least the principles on the basis of which it has been built. And last but not least, the accountability, which has been discussed previously. Of course, if we rely on artificial intelligence, we cannot expect but that is completely accountable. Because at the end of the day, when we talk about artificial intelligence, we are talking about math. So we are going to give to math, which is which is not an opinion, as we used to say, so it should be perfect, but we are giving to BAF basically the decisions of a variety of what happens to our day-to-day life, not least in this case about our health. So accountability is the paramount, is the most important characteristics that relate to artificial intelligence. There are some positions that have been issued by the authorities, and in particular by the European Parliament and the European Commission, as from 2017 until today. Basically, all of them came to the conclusions that wrote that there are no legal provisions that specifically apply to robotics. And robotics here is used as, as a synonymous of artificial intelligence. We know that they are different, but if you read through these documents, they sometimes use the term robotics, some other times they use the term artificial intelligence. So basically it is artificial intelligence, but that existing legal regimes can be applied, although some aspects appear to call for specific considerations. The only EU documents that specifically address the issues relating to artificial intelligence in relation to IP rights only deals with copyright, and mainly focus on the liability of artificial intelligence. The basic conclusions to which the European bodies come in relation to the interconnection between artificial intelligence and the IP right is that, in their opinion, there is not the need to completely, amend and modify the current legal system, but basically some few adjustments are needed to the legal system that we have nowadays. We will see that it is not really like that, but to some extent, what they say is can be shared, at least from a very superficial point of view. The current European Union IP legislation can be applied to artificial intelligence, but there is no document that addresses and gives indications about how the current legal system can be applied. So it is really a matter of interpretation. Then, what is mainly addressed by the bodies when we talk about artificial intelligence and IP is the issues of copyright. And the first point that comes to the spot is the fact that to have copyrightable work, and so to have an exclusive right in a work, you must meet the authorship requirements. And the authorship requirements are, first of all, creativity. So you must create something new, which of course can take something from what already exists, but must add new creativity to what is existing. The second is autonomy, meaning that it must come from the author itself. It must be an expression of the author. And the third requirement is that a copyrightable work must be not subject to external restraints. So it must have what is called the personal touch of the author. So it must be really the expression of the artistic imprinting of or fingerprint of the author. And as you can imagine, all these requirements are not easily cannot be easily related to artificial intelligence, because artificial intelligence can to some extent be creative, can of course be autonomous, because as soon as the whole stuff is made, then it can go by itself. But it is hard to say that it has a real personal touch, or at least as I personally know artificial intelligence today, I think that it does not have a personal touch. And when we talk about the personal touch, there is, an interesting image that comes to my mind. When I was, a young boy, I was a fan of Star Trek, and so basically I watched all, the movies, all the episodes, and so on. And one of the series, which was the Next Generation series, which was placed in the 23rd century, there was a robot which was called Data. So can you imagine how Star Trek was, very, very updated even, 30 years ago. And this robot was very smart, was very intelligent, but basically he had no empathy at all. And there was an episode in which he was playing violin with a perfect technique. I mean, it was really perfect. The technique of the arc, the technique of the, of all the notes. It was very, on the tone, but there was no, soul in it. So this is what is at risk with artificial intelligence. What distinguishes us as human beings from machines is the personal touch, is what comes from our soul. And by definition, a machine cannot have a soul. And this is an issue in relation to copyright, because if you can imagine that copyrights will become something that is the product of a sort of mechanicistic process, I don't know whether or not we will be able to call it a copyrightable work. So this is the main point that I see. But nonetheless, the EU Parliament, in one of its recent documents, accept to some extent the existence of what is called the computational creativity. As I said, you can have creativity, and it is opposed to the human creativity. And why computational creativity? First, because artificial intelligence is able, or is thought to be able, to produce new ideas using a software that works as a human neural network, especially when we talk about the deep learning, which try to make a network that is similar to our brain, similar, or at least want to be similar. The second is because artificial intelligence is provided by the programmer with many information that are fed with a lot of information. As soon as you have a lot of information, necessarily something comes up at the end of the day. So a sort of creativity comes up. Third, because artificial intelligence contains specific components that can we call and can we qualify as sort of receptor that can get information from the real world, which is basically through the data set that is fed, and is able to to make a creation independently, so without the human intervention. And so it's a creation of the machine. And so it's autonomous. It's autonomous. The last point is that once the programmer has inserted the data, the artificial intelligence has the necessary knowledge base and can elaborate further all the information. So it's like we give a kick to a ball where there is no force that can stop it, and it can go on without any limits. So that's the basic point. The conclusion is that the artificial intelligence is able to create unprecedented output. So can be something original. But again, notwithstanding there is a computational creativity as opposed to human creativity, still we do not have information about who is the author of the work created by the artificial intelligence. We have several pieces of legislation, mainly directives that have been implemented into the legislation of the member states. In Italy, we have, the copyright law, and all these pieces of legislations make reference to the fact that an author is either a natural person or a group of natural persons that created the work, or the legal person defined as the right holder under national law. So the current legislation is not sufficient to give authorship to artificial intelligence, because it is clear that it must be a natural person, so a human being, not even an animal can be author. There was some time ago a very interesting issue about an ape who created a piece of art. So he was trained to make paintings, and he did some very good jobs, really, because I mean he was trained, and to some extent he had a sort of creativity. And there was an interesting debate among commentators on whether the ape could be the author of that painting, and could be even the owner of the exploitation rights on the painting. And the answer from the majority of commentators was no, because the current legislation, at least in the European Union, does not allow an animal to be either the author or even more the right holder of a piece of copyrightable work. So, given that we do not have anything in the legislation, we can only try to make some thoughts about who could be the author of a copyrightable work. So basically we have four options. The first one is the artificial intelligence itself, or the programmer, or the user, or no author, or no exploitation rights. So everything goes into the public domain. I will start from the last one because it's the easiest. So this is not acceptable, because even in case something is made by the artificial intelligence, the work is the product of an investment. And so someone must have the economic exploitation rights. And of course, someone should be the author of the work. In our jurisdiction, the author of the rights has only moral rights when it decides to assign the exploitation rights to someone else. For instance, we have a specific rule in our copyright work that provides that the computer software that is made by employees is owned by the employer. But the person who made the computer software will always be the author and will always retain the moral rights, which cannot be assigned in our jurisdiction. Moral rights means that if he or she can oppose to the publication of the work, he or she can oppose to modifications of the work that goes against his honor and reputation, and so on. This is something very, difficult to envisage in case of software and the products made by an artificial intelligence, but still we have these moral rights that cannot be assigned, as opposed to other jurisdictions like the US, where the moral rights can be assigned, so are not crucial to the author. So no public domain, at least in my opinion. That would be the funeral of copyright. Then we go to the user, but the user is not first the person who created the software that applies, that uses the artificial intelligence. So basically the artificial intelligence. Second is not the person who feeds the data, and is only the person who take advantage of the product of the artificial intelligence. So the user cannot be the author of the work, because he can provide some information. He can even provide maybe some data to the artificial intelligence, but the big stuff is not made by the user. The user is the ultimate person who takes advantage. The programmer is a step higher than the user in the process of making the artificial intelligence, because he's the person who made the artificial intelligence able to work. But what he does is maybe elaborate and build the algorithm on the basis of which the artificial intelligence works, which is, of course, is something very important, but it's only the very first step of the whole process. And is the person who feeds the data to the artificial intelligence, or at least enables the artificial intelligence to get and collect all the data that it will use to create the work. And again, notwithstanding the intervention of the programmer, the artificial intelligence is supposed, otherwise it will not be an artificial intelligence, to act autonomously. So again, the programmer can have the copyright on the software that makes the artificial intelligence working, but not on the product, the work product that is created by the artificial intelligence. So it's something different. You can imagine like Microsoft Word that you use to make a document, and the document that you make using Microsoft Word. So Microsoft, of course, is the owner of the copyright on the software, on Microsoft Word, but can never be the owner of the copyright on the document that you will create. But the problem with the artificial intelligence is that at the same time, the program is also the author. So there is no division between the program and the author, because when we use Word, the program is the program, but we are the authors. And so this is undisputable. With the artificial intelligence, it's not like that. At least it's a bit blurred. And then the artificial intelligence itself can be the author, is a question. I don't know. I don't think so. For the same reason why it is not possible to give the ownership and authorship to anybody who is not a human being. So for sure, artificial intelligence will not be able to have moral rights, because artificial intelligence has no morality. Has no soul, has no mind, has no relationship with other people. It can have a relationship with other artificial intelligence, maybe, but it's not the same thing. And in this regard, we must be very careful, because if at some point we will provide the artificial intelligence with moral rights, we will put at risk ourselves as the only living being that can have moral rights in this world, at least. So it is a very problematic issue. So basically, the answer to the question who can be considered the author of artificial intelligence work, there is no answer. Not for the moment, and I don't want to give my answer because I'm not the legislator and I'm not an important commentator at this. I have an opinion, but I will not disclose it to you now. Very similar approach applies to patents, whereby the person of the author is less important, but it's still provided of rights, at least in our jurisdictions. It's the same for the copyright. The author cannot assign its moral rights to anybody. But the exploitation rights of patent is more easily, I would say, generally attributable to to a person who is not the author, and specifically to the companies who are the employers of the inventors. But again, in the current legislation, we have at least 3 issues that cannot nowadays be considered compatible with the essence of artificial intelligence. The first one is that across the world, any kind of legislation provides that patent, so an invention, must have an inventor, who must be a physical person. And you can imagine that in some jurisdiction like the US, the very first owner of the patent is always the inventor. It's not the employer, it's not a third party. And the inventor, when the patent is filed, of course with the money of the employer, is requested to sign an assignment. So, and this is the reason why, for instance, when you identify the patents in the US, you do it citing the inventor, not the owner, which is different from the system that we have in Europe. So, necessity to identify an inventor. Second, the invention must be attributable to an applicant or to an inventor, which must be, or again, either a physical person as per the inventor, or if it's to the applicant, and so the owner of the exploitation rights, at least an entity. So, is artificial intelligence an entity? No, not at least in the current legislation, because it's not a physical person and it's not a company or an association, a foundation, and blah blah blah. When the applicant is a legal person, the third point, as I already explained, assignment from the inventor must be made to the applicant, or the ownership is provided to the applicant by the law, like in the US. So, can artificial intelligence currently, and as we know it now, as we know the way it works nowadays, assign rights to a third party? Probably not. Maybe it could be programmed to do so, but it will not probably be a real act of will of the artificial intelligence, because it will probably be like the execution of like a routine or of a specific algorithm inside the machine learning system. So it's not a true assignment, because you must have the proposal and the acceptance and the will of the parties. So my conclusion now is that also in the case of patents, intelligence cannot be the author/inventor. And now I will go to the issues of the liability, which are also very, very interesting. As I explained before, we are now using artificial intelligence coupled with other technologies. I mentioned here the CADD, which is the computer-aided drug discovery, which is increasingly availing itself of the artificial intelligence. It was explained before in Mr. Mazzin's presentation. It's basically the use of software to identify molecules that could be, could be used to carry out research and that could become drugs in the future. And this can be made with artificial intelligence, which can make a lot of simulations. The same is with the blockchain, which also can avail itself of the artificial intelligence to manage, the trustworthiness of the whole process and the certification of the process itself. But when we use all these devices, and ultimately when we use artificial intelligence in the clinical research and practice, we face liability necessarily, because any human activity leads to liability. Whether or not it is made directly by a person or through, a company or by someone or something that should be under the control of a person. Ultimately, the person is responsible. Is responsible in our system from the criminal point of view, the person himself or herself, because the criminal liability is personal, cannot be, of course, directed to a company. But from the civil perspective, the liability is personally to not only a physical person, but to an entity, but is someone or something that is recognized by our legal system as a person. In the clinical practice, we have also specifically, as I mentioned before, the activities of diagnosis and treatment, which are the most important and which give rise to the most important issues about the liability. Because if you misdiagnose like a cancer or a condition, of course, and the person then dies or even has worsening conditions, you face liability. If you don't treat properly a person, you face liability. And again, I placed the artificial intelligence here on the top, but on the side we have also some instruments that can or not avail themselves of artificial intelligence, which are the augmented reality and the virtual reality. Because in the diagnosis and treatment clinical practice, we are experiencing an increasing use of this kind of devices. You can imagine, for instance, a system, an augmented reality system, which is provided with an artificial intelligence system as well. When you are in a surgery, the surgeon can look at something in the operational field, and the artificial intelligence can detect something that is not working properly there, maybe a lesion inside, and pops on, like Google Glass, a potential solution, or recommends a technique that can be used by the surgeon throughout the surgery. So these devices, these systems must be accountable. And of course, again, we have an issue of liability also in this case. So when we have liability, what we have to do? We have to do basically three things. The first one is the risk allocation. So we must be able to allocate the risk of the liability to the right person. The second one is to provide for an indemnification system, which means that if someone claims damages, the right person must be responsible, risk allocation, and indemnification must indemnify, must be held ultimately responsible for paying the damages to the person who had suffered the damage. The third point is an insurance, because in our world, we are not all, like Apple or Google or Amazon, who are very rich and could face any kind of liability. So we necessarily need to avail ourselves of insurance companies to cover the damage, because we cannot imagine that that a company that manufactures and sells a device, a medical device that is provided with an artificial intelligence system that could potentially create very, very significant damage, that company will be able to face the damages claim. So when we are looking at agreements with companies that provide artificial intelligence system, we necessarily have to address these 3 points. It's basically a matter of negotiating proper clauses, and that's not easy, at least in my experience. I had already the opportunity to make some negotiations with software company providing for artificial intelligence systems, not in the healthcare, frankly speaking, and luckily, but in other fields, and it's difficult for them to understand the point, because in their minds they are software providers, and they say, as they usually say, we provide the software as is. We do not want liability. We can give you like a very limited period of warranty. The software cannot be perfect. You always have to maintain the software. You have always to carry out error corrections and so on. And then the step I am trying to do to create a sort of awareness with those companies, whether they're my clients or are my counterparties, is to say, no, you're not only a software provider, you are an intelligent service provider. You must treat the software as a person who is carrying out a work on your behalf. Of course, it's not easy to explain and it's not easy to accept, but at the end of the day, this is the point. And so the negotiation of these 3 points is of critical importance for both the parties, whether you are the provider of the system or the user of the system. In any case, and it must be, in my opinion, balanced. You cannot put all the liability on the provider of the system, because otherwise it will go out of the market in 1 week, and you cannot, of course, have the user of the system to face any liability, because at the same time, either it will not be able to reimburse the damages to the ultimate user, in the case of healthcare, to the patients, or it will also go out of business in very short time. At the European level, there is awareness about the fact that artificial intelligence can create damage, because there is awareness of the fact that artificial intelligence, although artificial, is human activity, is synthetic human activity. And so there is awareness of the fact that, as opposed to the issues that I explained before relating to the intellectual property, the current rules are not sufficient. I mean, there is nothing that can be adapted nowadays to make sure that damages that are created by artificial intelligence are properly addressed and properly reimbursed, because the current situation enables, to some extent, either the system provider or the system user to decline liability and to say, it's not my fault, the fault is of the artificial intelligence. But that's not the solution, because it's like saying the fault is like of a bird that is flying. So ultimately, as they say, a person must be responsible. The problem is that these European documents only create awareness on the issues, but do not give any kind of solution. The only piece of legislation that we have currently, as I said, is the directive on defective products, which has been implemented in our system by the consumer code, which says that the ultimate responsible is the producer, the manufacturer of the product. But which also says that consumers can always claim the damages to the person or to the entity from which they purchase the defective product. And then the distributor, the reseller, the retailer can go up and claim the damages up to the manufacturer, who is the ultimate responsible for the damages. And the current system provides for a strict liability, meaning that the injured person does not have to prove the fault, the negligence of the producer. I mean, there is a sort of automatic link from the subjective standpoint. So as soon as I have a damage, because I use the product and the product is defective, my damage must be reimbursed. Whether or not the producer was negligent is not relevant. In, of course, the relationship with consumers. B2B is different because, of course, the relationship between companies is based on, a professional attitude towards damages. But I think that when we talk about the use of artificial intelligence in healthcare, we should more be focused on the liability towards consumers, because the patient is a consumer. And we could try to address the issue of liability from different perspectives. I've already addressed the issue of the strict liability, but again, strict liability of whom in case of artificial intelligence? Again, of the manufacturer of the system, of the user. We can even try to imagine a fault-based liability, which could be more compatible, because, for instance, we can envisage a system in which the user of the artificial intelligence system face liability because it was negligent in selecting the appropriate artificial intelligence system, because it did not conduct a sufficient or a proper due diligence on the accountability, for instance, of the system. But again, providing evidence of this kind of negligence will be quite difficult, especially in case this evidence must be provided by the consumer, by the patient, who has not the legal and the economic instruments and tools to do that kind of work. We can even imagine a sort of vicarious liability, meaning that any damage that is caused by the artificial intelligence is automatically of either the user or of the company who provided the artificial intelligence system. But that would be like what we call in legal terms a fictio iuris, meaning that something that is not real. And so it will not probably allocate the liability in the right mode. We can face and address the issue of vicarious liability, distributing evenly the liability between the provider of the system and the user, but that would be like a sort of Solomonic decision, and could not reflect the actual needs of the patient who is damaged and injured, and would not be an efficient system for allocating the liability from the economic standpoint. We can even imagine the artificial intelligence own liability. I think that we can only imagine it, but in practical terms, it should not work, because again, artificial intelligence it does not even have the funds to pay the damages. And I'm very skeptical about the concept of electronic personhood that some commentator has proposed. What has been not proposed, but mentioned by the European Commission in one of its documents, and in particular the document of April 2018, but it's only, I mean, a mention, and without any additional explanation and without any specific proposal, is to provide for an insurance scheme working on the basis of a sort of compensation fund. It's something that I think, and I imagine, could be imagined as similar to the system we have now in Italy for the reimbursement of damages for the victims of car accidents. What we have in Italy is a fund that is available for any person who is victim of car accidents in case the person who caused the accident and definitely who caused the damage has not an insurance cover. The fund is provided by an international convention, which is the Strasbourg Convention of 1959, and has been implemented in Italy since decades, and in the last piece of legislation in the insurance code. And the fund is funded by insurance companies. So the insurance companies, part of the money they take from the insured people is allocated to the fund, which must be of a minimum magnitude, and this is used for the reimbursement of the damages. We can imagine something similar for artificial intelligence. Of course, a very big problem will be who will be the company that will be called to fund a sort of this kind of compensation fund. And we can imagine that this will be made on the basis of the sectors. For instance, companies providing artificial intelligence systems in the healthcare or in the automotive and so on. It's something that can be explored. I don't know, but that could be a reasonable solution. Okay. I'm always going to finish. Then some regulatory hints. As I said, the only authority that has really addressed the issues of artificial intelligence, specifically in relation to healthcare, is the FDA, who, with a proposed regulatory framework for the modification to artificial intelligence and machine learning based SAMD. SAMD means software as a medical device. There are basically four issues and steps that are addressed by the FDA. The most important is that artificial intelligence applied to medical device must be adaptive. So when the product is launched on the market, it is presupposed that it will be changed, it will evolve, and this evolution must be already foreseen by the manufacturer when the product is placed on the market. So in asking for the authorization to market the product, the producer must submit a predetermined software change control plan, which will be something that will be used by the manufacturer to address any issues that can pop up throughout the use of the artificial intelligence software, or in case a set of data that was not, envisaged when the product was placed on the market must be added in the second point. And in this framework, the FDA provides that in case any amendment to the artificial intelligence system is coherent and consistent with this change control plan, no modification to the authorization will be necessary, because it is something that is already provided. It was already proposed by the manufacturer. In case, as on the opposite, it is necessary to make amendments to the system which were not included in the change control plan, then a new authorization, or at least an amended authorization, will be necessary. To my knowledge, there is not yet an application. I don't know if you have any other information about that. We will see whether or not it will work. I think that it will not work as the FDA is thinking, because I think it's not that easy to, imagine any kind of change that you will make to a software for using, artificial intelligence, because you cannot even understand how the artificial intelligence will actually evolve throughout the time and depending on the data that it will use. Another point that the FDA is stressing in this document, that there must be full transparency and a very, strict monitoring activity, because otherwise all, the system can collapse and it will be sort of anarchy. And of course, the FDA does not want anarchy, and none of us wants it. So in the end, the ultimate question on all the legal aspects that I talked about now is that, do we need a complete upheaval of the existing legal system to address the issues raising in relation to artificial intelligence, or do we just need simple adjustments of the existing legal system? There is no answer, because the answer is modular. It depends by the field. It depends by the interest and the rights that are at stake. So thank you very much for your attention.